Welcome, everyone. Just going to let folks in from the waiting room right now. As I'm letting folks in, I just wanted to let you know that we are running about 5 minutes late. So I'm letting people in from the waiting room, but I'm going to ask everyone to just bear with us, and we'll get started in about 5 minutes. So please go ahead and sit tight, and we will be right back with you, okay? Thanks so much. Hey, once again, everyone, thanks for joining us. Give us a few minutes. We are running just a few minutes late. The webinar will be an hour. Okay, we're expecting it to go from 1 o'clock to 2 o'clock. We'll be finishing up right at 2 o'clock. All right, you guys, welcome. Michelle has joined us, so we're going to go ahead and get started with our webinar. Um, We are running a webinar today that is called the Divorce Foundation Series, a 101 guide to Washington State family law and what to expect. I'm going to turn it over to Michelle in just a moment. Very briefly, I'll tell you who I am. I'm Melissa Rosenberg, and I'm a therapist here in Seattle. I do a lot of different things, but one of my focus areas is working with clients who are navigating various stages of the divorce and separation process. I work with both individuals and couples, but today I am here to help moderate this webinar. And so what we're going to do, Michelle's going to deliver a bunch of great information about various pieces of the divorce process and the 101 needs to know. And then we're going to take questions as well. So if you have questions today, you can go ahead and pose those to me in the chat. Those will just come to me and I will, um, you know, post them to Michelle, to the panel here, and see if we can go ahead and get as much of that answered as possible. Just going ahead and let you know right now that if it is too specific to your case, we won't be able to answer it. We're answering more general questions today that might be useful to everyone. If you do have something that's a little more specific, I can try to kind of piece out what the themes are, but recognize that things are going to be a little bit more general on this webinar. So here we go. I'm going to turn it over to Michelle and we will get started. Thanks for your patience.
Thanks for your patience today. Hi, I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. And today we're going to talk about getting divorced in Washington. Basically, a guide for you to know what are the issues you're going to face, what are the next steps that you need to take, and really, like, can you get divorced in Washington? What does that even mean, right? And we'll also talk about the differences between divorce and legal separation. That's a really important thing that I think often gets overlooked. So before we get into it, I will tell you this. I am an attorney, but I'm not your attorney. Okay. So the thing to know about that is that anything I say today does not form an attorney-client relationship. It is to be seen as information and not legal advice. So you should rely on an attorney that you actually have a consultation with and that you actually have attorney-client privilege with. So it's very, very important that you understand that as we get started. So let's talk about some basics. Okay. The first thing I'm going to talk about is what are the four main issues in a Washington divorce? And sometimes there's other issues, but these are the four big ones. First one is division of debts and assets. So what that means is you're going to need to look at what are the debts and assets in your case, what's community property, what's not community property, and how does it get divided? Okay. The second thing that you're going to need to look at is spousal maintenance. Is spousal maintenance going to be an issue in my case? Does that mean, is someone get it? Are they not going to get it? Who's going to pay it and how much? Okay, that's the second issue. The third and fourth issues apply if you have kids. The third issue is a parenting plan. What is a parenting plan going to look like in my case? You can't get divorced without one. So we'll talk a little bit about parenting plans, what they mean, what they cover, all that kind of stuff. The last thing is child support. So once you have a parenting plan and you know who the primary residential parent is, then you know what the deal is with child support and who has to pay who how much. Okay, so those are the four main issues. There are other issues as well that can come up. Issues that involve protection orders, restraining orders, those kinds of things. Issues that might involve travel with your children, all kinds of little issues that kind of come under the big umbrella issue. But protection orders and restraining orders are another primary issue. That also can include financial restraining orders. So those are the main issues. As we get started, though, let's talk about this. How long does it take to get divorced in Washington? Everybody asks me this. Everybody wants to know. So here's what I would tell you. Divorce in Washington is a marathon. It's not a sprint. A fast divorce is usually one where you might have a prenuptial agreement, a postnuptial agreement, something that already dictates what's going to happen financially. And that's not really common, okay? So in a situation where that's not really common, you have a lot of things that you have to work out, and that can take time. It can mean getting valuations. It can mean getting a home appraised. It can mean, if you're parenting, getting a parenting evaluation done. A lot of different things that you're going to need to do and that you're going to need to know about, okay? So it's not always, quick and easy. I have a friend that wrote a book that's really good, and it's called I Just Want This Done. And I think that's how a lot of different people feel. You just feel you want it done. It's like a Band-Aid. You want to rip it off. You want to be done. I totally can relate to that and understand it. But the fastest result is realistically not usually the best result. So it's important that you know that. But anyway, how long is it going to take? That's kind of the big question. The minimum time it can take in Washington is 90 days from the time that you file and serve a divorce petition on someone else, or from the time that they accept service. But that's a really, really fast divorce in Washington. Like I said, there's a lot of things that need to be worked out, and it can take a lot longer. So the average time, I would say, if you have assets or parenting, and it's even a fairly cooperative divorce, an average time on a divorce is probably going to be somewhere between 6 months and a year. 6 months being fairly short, a year being fairly standard, 9 months kind of being in the middle. And that's by no means a guarantee. If you have a case that's going to trial, you're probably going to trial somewhere between 1 and 2 years. So in King County, which is where many people's cases are, although some might be in Snohomish, Pierce, Kitsap, a number of places. But in King County, I'll use that as an example. You're going to have a case schedule that's issued when your case starts, and it's going to have a number of deadlines on it. And those deadlines are really important because they kind of set benchmarks for when certain things are going to happen. You'll have a trial date that's a year from when your case is filed. You'll have a dispute resolution deadline, which is typically when you have to go to mediation or participate in some form of dispute resolution. And that's going to be 10 to 12 months from the time that your case is filed. Those things can happen sooner. Well, trial can't, but dispute resolution can happen sooner if that makes sense and you agree for it to, but you can't force the other party to participate in dispute resolution sooner. So that's important for you to know. So right from the start, I like to talk about realistic timelines. Another really good question is, who can get divorced in Washington? Okay. And that's where we talk about something called jurisdiction. Jurisdiction, what that means, it's a word that you might hear in your case. You might not hear it if it's not, there's no question about it. But what it really means is, does the court have authority to enter orders that affect you, your spouse, and your kids? Does the court have jurisdiction? So if your kids haven't resided in Washington for the last 6 months, and if there's not a really specific reason why, the court might not have jurisdiction to enter orders over them. 6 months is kind of the timeline for when jurisdiction takes effect over children. Okay. Just like if your kids move to another state with one of you and they've only been there for a few months, Washington still might have jurisdiction because they haven't been there for 6 months yet. So, as far as you, if you live in Washington, you can file for divorce. But whether the court's going to have jurisdiction over your spouse is another question. If you got married here and you both live here, obviously, of course. If you got married somewhere else and you both live here, yes. It's not about where you got married, it's about where you're living and where you're getting divorced. If you move to Washington and you're a resident here, but your spouse never lived here, you didn't get married here, your spouse has no ties to the state, you might be able to get a divorce entered here, but the court might not have authority over your spouse, and there might be a lot of questions there that can get confusing. So those are a few things to know. But generally speaking, if you both lived here during the marriage, you can get divorced here, or if one of you remains here and the other person moved elsewhere. So that's really important to think about. You want to make sure you're in the right place, because if you should be filing in a different state, you want to know that and you want to keep it in mind. Okay. So before I get into the four main issues in divorce, I'm going to also tell you a very helpful list of financials that you can get together that are going to help you as you start your case. But before I do that, Melissa, are there any initial questions I should answer?
We have one question here, which is, it's a question about if a spouse is constantly keeping bank accounts or details secret and not sharing passwords and changing them a lot, what can one do? And we get that question a lot, I think, around kind of if somebody's being shady or dodgy about financials. So I wonder if you want to respond to that.
Sure. Here's what to think about and what to know. In your case, it's not uncommon for one party in a marriage to handle most of the financials. I mean, that doesn't always happen, but sometimes one person has all the financials, they have all of the access to all of the details and all the information, and maybe you don't, right? And then you go into a case and you're thinking, am I going to know what there is? Well, yes, you're going to have to know what there is financially in order to ever be able to agree on anything. So if your spouse hasn't provided anything, if there's an active case, you can request financials through an attorney. And more likely than not, you're going to want to serve what's called formal discovery, which are interrogatories and requests for production, where you ask the other party to produce the financials that they have. And they have to. They honestly don't have a choice. If they don't, and there's a reason they don't think they should have to provide something, they have to provide a legal basis and an objection for it. So you might not have access to the financials now, but if you're in a case, you can always serve financial discovery to get it. I hope that helps. Okay.
That's perfect. I don't have any other questions, but I do want to
Great.
also say one other thing. There's also the Q&A option at the bottom of your screen. If you choose to submit a question that way, that's also an option. Just note that if you want to mark yourself as an anonymous attendee, you can. Otherwise, your name will come up with your question. Either way.
Okay, perfect. So let's do this. Let's talk about the basic financials that you should get together. Okay. So, number one, every case, and I want to tell you this because I want you to have very realistic expectations for your case. You might think, oh, I got the financials together that Michelle told me to, I'm done. No, you're not done. So, let me tell you that. These are basic financials to start. You might need to provide additional financials because of discovery. You probably will need to supplement your financials and update these financials a number of times because financials become what we call stale. So, you are also going to need current financials later in your case. But this is kind of the basic set that you're going to want to get, and it's going to be helpful for you. Last 2 years of tax returns. So the last 2 years of tax returns should also include your W-2s. They should include all the schedules, not just like a summary page from TurboTax, your entire tax returns. And I should also say this at the start. If you don't have all of the financials, don't worry about it. Like the other person that just asked, maybe you're not the person that has all the financials. Maybe you're not the person that has access to them. If that's the case, like that's totally okay. And that's the kind of thing where you should just provide what you have, and then we'll go ahead and get you the rest of it later. Like, but it's not a situation where if you don't have it, you can't get divorced. Some people will be like, well, I don't have 2 years of tax returns. I don't have access to the financials. Can I not go ahead? Do I have to wait and get it from the other party? No. That's a situation where then your attorney will try to get it in the case with discovery. So this is just what you can get if you have access. 2 years of tax returns, complete returns and W-2s. Here's the other thing you'll need: 6 months of pay stubs. I recommend a year because it's better to have a look at a whole year of your earnings, especially if there's questions about bonuses, but at least 6 months of pay stubs, up current, 6 months current. Um, so again, prefer a year, but 6 months. 6 months of statements in any account that you have a financial interest in, no matter where it is. So that's going to be bank accounts, that's going to be 401ks, it's going to be taxable accounts, it's going to be any kind of account at all. It's also going to be debt accounts. If you have a mortgage, if you have credit cards, if you have personal loans, any account you have an interest in, 6 months of statements. A year also is helpful, but it's less important. The last 6 months is a really good starting point when you look at that. So those three critical things. If you have a business, you're going to want to have a business tax return, and you're going to want to have like your most recent financial reports. You probably have a monthly P&L, and you probably have quarterly reports. You're going to want to get those together too. But what ends up happening is we get 6 months of statements, and then we can look at those statements and see what else we might need. We look at your last two tax returns. We can see what else might be missing. It can also be very helpful to pull your credit report in the beginning. And you can pull 3 credit reports free every year from each bureau. You can go to annualcreditreport.com. I don't get like anything for telling you to do this. It's just a helpful thing. And you can pull your credit report for free once a year. That can help you understand and know like maybe if your spouse has opened other cards that you might not have access to. So pulling a credit report in the beginning is really, really helpful. If you're later in life and closer to retirement, it can also really be helpful to get your Social Security statement that you can also get online so you can see like what your benefit is if you're nearing retirement age. That's going to be something that's probably going to be asked for in a long-term marriage or in a marriage where you're close to retirement. So those are some very basic financials that you can get from the beginning. And then let me give you a hint on how to organize them because this will save you time and money. You can put them all in a folder and send them to your attorney, but then you're going to actually have to pay for them to figure out what's there and to organize it. You can speed up that process. What I recommend that you do is create like a master folder that's your financials. Inside of there, create one subfolder for bank accounts, one for credit cards, one for investment accounts, and then put subfolders in there. So in your bank account folder, you could have Chase, and then in there you could have savings ending in 1234, checking ending in 3456, and then you could say October, November, December. But the more that you can make it easy, so top level folder and then subfolders detailing what's in there, the better it's going to be for you, and the more money that you're not going to spend on organization of things. Is that always going to happen? Like, are you always going to, be able to organize things perfectly? No, but it goes a long way in being able to have your attorney's team know like what you actually have and then what's missing and help fill in the blanks. And sometimes we need to fill in the blanks from the other party. Okay. So there is your basic set of financials. Gathering your resources at the beginning of divorce is really important. And that can mean gathering financials and what you have access to. All right. So, Melissa, before I move on to talking about division of debts and assets, is there anything else that you want me to answer?
Question here is asking about the different processes of divorce. They said they've
Mhm.
heard about collaborative, contested, uncontested. What do they mean? How best to decide how to proceed? So
Yeah.
just, I don't know if this is the right time for that
Yeah,
question.
this is a good time to talk about it. I like to talk about that at the end, different approaches to divorce, but I can talk about that now. So here's what to think about. Okay, divorce can look a lot of different ways. Some people think that if you're not doing a collaborative divorce, then you're going to court for everything. And that's actually not true. I would tell you that probably 90% of cases don't go to trial in family law. They're resolved through what I would call a more cooperative divorce process where both parties have attorneys and both parties, negotiate through counsel and have someone advising them on what to do. So that's more of a cooperative, it's still contested, but it's a cooperative divorce where you try and proceed amicably, even if you both have attorneys. Okay, that's different than collaborative. Collaborative divorce, and I would say most divorces fall into that first category. Or it might be a situation in that first category where you have to go to court to have something decided, but then, you're back not in court. You're not in court for every little thing. So I would say that's kind of a cooperative hybrid divorce where you have representation, but you're not in court for every little thing. That's most divorces, and you don't end up in trial. Second type of divorce is a collaborative divorce. And collaborative divorce, in my opinion, I am collaboratively trained and I've done collaborative divorces, but I actually don't think that they are for most people. And oftentimes we get cases where someone has been in the collaborative process for a really long time and it's failed. And then we have to step in and help them. A collaborative divorce is something where people sign a participation agreement and you enter into a process that's actually defined under Washington law by a statute where you both agree no one will go to court. No one will serve that formal discovery I was talking about to try to get access to financials. No one will do anything like that. Everyone agrees to cooperate. And then you'll have what's called the collaborative team, and you'll have agreed upon financial people. You might have somebody to help you with parenting. You might have a realtor, but you'll have people on a collaborative team, and you'll have to agree to both use those people. And then you'll have meetings in what's called the collaborative container, where you and your collaborative attorney, the other party and their collaborative attorney, and these other parties will meet and talk about the divorce and try to negotiate things all together. To me, that's a really unhealthy process for a lot of people. A lot of people want privacy to negotiate, and it's very difficult for them to negotiate sitting across from the other person. It usually doesn't end up getting anywhere. For some people, it's a great process, but it also requires a series of meetings and can go on a long time. And like I said, I've had people come to us who have been in the collaborative process for a number of years, and it hasn't worked. Here's the other thing about the collaborative process. If it fails and one party doesn't want to do it anymore and you can't reach a resolution, you have to start over with new attorneys. The collaborative participation agreement requires that if you are not in the collaborative container, everyone has already shared everything and there hasn't really been the same level of confidentiality. So you have to start over with another attorney. So that's very frustrating for a lot of people as well. So collaborative, we've talked about hybrid cooperative, and then there's like just a full scale litigation divorce where every single thing you're fighting about, every single thing you're going to court about, and you're definitely going to trial. That doesn't happen in very many cases. So, I mean, those are some approaches. Another approach is what I kind of call the kitchen table approach, where you and your spouse are trying to work out things across your kitchen table. You're trying to not have attorneys. Maybe you go to a neutral mediator who you think is going to help you work things out. Some people are successful with that, but I caution you on that too, because a neutral attorney mediator or a non-attorney mediator, doesn't matter which one, if you aren't represented, they're not there to give either of you legal advice. They're there to do what's called a facilitative mediation. They're going to facilitate you trying to come to agreements on things. They're not going to tell you, though, hey, this is a really bad deal for you, because they can't. That's not ethically their job or their responsibility. So, in a facilitative mediation, that's very different than a mediation if you both have counsel and you're getting an evaluative mediation, where your attorneys told you what they think. Other parties in the other room, you're not across from each other, and then a neutral attorney mediator is going back and forth between the rooms and evaluating cases and trying to bring you close together. In my experience, that settles over 95% of cases. The ones it doesn't settle, there's usually a really good reason why. Sometimes it's one party being unreasonable. Sometimes the issue and dispute is too big to come to terms on. But yeah, so a kitchen sink divorce where you guys are trying to work it out yourselves is very different. Sometimes I'll have someone come to me and they've gone through that process and they've gone to a facilitative mediation and then they've come and they're like, oh, hey, here's an agreement Because if you do that, you still have to have someone write it up for you. And they'll say, "Hey, here's an agreement. I want you to look over it before I sign it and before we finalize it." And I'll look at it and I'll say, "Well, you agreed on a 50-50 division on assets. That's not a good outcome for you. Maybe this person has been a stay-at-home parent, maybe the other person makes a lot more than them, whatever it is. They might have thought a 50-50 was a really good outcome, and the mediator didn't tell them otherwise because that's not their job. But then I'm telling you, well, you just left a bunch of money on the table. I wouldn't agree to that."
Mhm.
Or someone, "Oh, you're giving up too much." Like you don't really know if you don't have legal guidance. So that's something to keep in mind. And you don't get a do-over. Like once you agree to something and you sign it, you're done. So it's really, really important that you have someone take a look at it. So that is the basics on something for you to think about.
Can I piggyback on that with another question here? If both parties want to enter the divorce process amicably,
Hmm.
do they both need an attorney? So the example here is that the petitioner has an attorney and serves the respondent. The respondent does not have an attorney. Do they have to
Hmm.
get one?
No, they
Okay.
don't have to get one. I mean, if they want to get one, it's probably going to be better. If one, here's why. Because if the other party doesn't have an attorney, they don't necessarily know like what's fair and what's not. They could be holding a position that they think is really fair and they don't really know. So I'm always glad when someone else gets an attorney. If they don't, though, they don't have to. I've had plenty of cases where one party just decides not to have an attorney. I mean, they don't have to. They might be getting advice like behind the scenes or they might not, but they don't have to. You can't force somebody to get an attorney. I mean, that
Okay.
absolutely not.
Mhm. And then I do have one other outstanding question here. This person's saying they filed for divorce, but the spouse refuses to leave the residence, so they're planning to move out instead. Currently, I'm on the mortgage, home insurance, payments, all the things. How can I obligate him to take over payments? Am I still on the hook even though I no longer live there? What does all that look like? They're going to move out. They don't really want to, but they are, and don't want to be, obligated to all of the financials of the house, even though they no longer live there.
Um, okay, here's the thing to know. I'm trying to think of the best way to explain this without kind of making it overwhelming. All of these issues about like who's responsible for what, those can be dealt with in what are called temporary orders. So temporary orders is kind of what establishes a new status quo. So if you've moved out and you're not living there and your spouse is living there, and it's a community home, you're still both responsible for it, right? But you have to pay for where you're living, and they have to pay for where they're living. If there's a dispute about that, and you're worried they're not going to pay the bills, or they don't have the money to pay the bills, then you're probably going to want to get a temporary order that says who's paying for what. So you can temporarily like alleviate yourself from that responsibility, and then those things can be divided in final orders. Does that make sense? I
Yeah,
hope that makes
that's
sense. Like
helpful.
I'm trying to explain it in a way that doesn't go down a pathway that doesn't make sense. But you're not necessarily going to be expected to pay for something that where you're not living. But here's the thing, and I have had to have this conversation with a lot of clients. You might not be living there, but if you're the only party, it really depends on your situation. If you're the only party that's making any money, and the other party doesn't have a job and they're just taking care of the kids, they're going to be expected to get a job and they're going to be expected to pay bills, but no one's going to expect them to do that right away. So you could be in a situation where you're paying for two living situations. But if you both have jobs and can pay for your own bills, then no. So that's what I'm saying. Like it's going to be a very fact specific evaluation. So you're really going to want to talk to someone about the best way to proceed.
But along those lines, this person's saying, I assume there's a lag between serving someone and then temporary orders going through. So what do you do in the interim? How do you establish who gets to stay in the house and the kids' visitation, the schedule, and all that when there's not yet?
You better file for temporary orders right away.
Yeah.
It could take a little while to get them. That's true, depending on where you're at. But if you have an attorney, then the idea is that your attorney will reach out to their attorney or to them and try to negotiate something quickly, even if it's in the interim. And usually you don't have a situation where both parties are fighting to stay in the house because at the end of the day, that's not good for anyone. But if someone's like refusing to leave the house and both parties are refusing to leave the house, hopefully you can broker some kind of an agreement. And a lot of the time, people are way more willing to negotiate with an attorney than they are with each other. But knowing that like a temporary orders hearing is coming up, very often it's common to say, "Hey, we're asking you to move out. The hearing is set for this date. If we can come to some agreements on things beforehand, like now, we might not have to have that hearing." And that's better, but sometimes people knowing that that date is coming up is enough to get them, to move out. So it's a fine line and it's a negotiation process. So, okay.
Great questions.
Yeah. One thing I want to do is I want to touch on essentially the four main issues in a way that makes sense to you that will give you a good takeaway. Community property. So when we talk about dividing destined assets, that's something that has to happen in literally every single case. So you're going to have to deal with it no matter what. And you might think, well, we don't really have much of anything. Well, no, you might not, or you might have a lot. It doesn't really matter. You still have to say who's going to take every single thing. Okay. And one thing for you to know is, what is community property? Right? We're a community property state, but what does that really mean? Well, what it really means is that everything from the time that you got together and got married, sometimes even before that, till the time that you separated is community. And that means that both parties have an interest in it. And the name that's on the account does not control. So I like to give this example. If you have a 401k, it's in your name, right? Because it's through your employer most of the time. And only your name is on it. But if all the money that you earned in it, you earned while you were married, both parties have an interest in it. Your spouse has an interest in it. Is their interest half? Is it less? Is it more? I can't tell you that for sure, but they have an interest in it. If your spouse has a savings account that they have in their name, they've been putting money in, and your name is not on it, but all that money came from during the marriage, you have an interest in that too. So name on the title of the accounts or the assets doesn't matter. It's what was acquired, and that it can include debts. So debts or assets that were acquired during that community period is what is community property. Okay. And then you got to think about, how am I going to divide it? Well, we're not what's called a 50-50 state. So what that means is we don't just divide community property in half. Some states do, like California is a really good example of that. It's a big state. It's close to us. It's community property state. In California, nobody cares how long you were married or how much money you're making. They're just going to divide that pie in half. That's what's going to happen. Okay. In Washington, not the case. And a lot of people think that that is the case. So that's why I like to make it really clear for you. What it means is we have what's called a just and equitable standard, which is supposed to mean what's fair. And when I promise you what I think is fair or you think is fair, it's all going to be different. So forget about that. Think about what is equitable. And what is equitable means that two primary things are taken into consideration when thinking about how assets and debts get divided. One, the first thing that gets taken into consideration is, how long is your marriage? If it's a short-term marriage, a mid-term marriage, or a long-term marriage, that's going to have a bearing on what the division should look like. In a short-term marriage of 5 years or less, the idea is to be backward-looking and kind of put people where they started. Maybe you split things equally and you move on. Nobody's relied on that community long enough to really, be entitled to more, unless there's a really big disproportionate division. Midterm marriages, which is most marriages, that's like 6 years on up to 24 years, basically. That's a different situation. And the longer that you get into the midterm marriage range, the better argument there is for a disproportionate division. So what I mean by that is that the party who makes less, like we would call them the lesser moneyed spouse, they're not going to recover financially as fast from the divorce. So the idea is to have the parties exit the marriage on equal footing, and that can mean one party taking more. So somebody might take 55% or 60% of the community. Really, what's equitable? So that's length of the marriage. And the other factor, which I just touched on, is the financial situation of the parties at the time you're getting divorced. So okay, one party makes 300,000 a year, one party makes 25,000 a year. I mean, that's like very disproportionate. What are the parties' ages? Like, how many working years do you have left? What's the level of education? Does somebody need worker retraining? Both parties are going to have to work. Even if you've been a stay-at-home parent, you're going to have to work. That's just how it is. Being a stay-at-home parent is being voluntarily or underemployed post-divorce. So at some point, you're going to have to work. But if you don't have an income history and you might need to go back to school or you need to get in the workforce, you might never make as much as the other party. And so you might take more of the community to and do equity in exiting the marriage in a midterm marriage. In a long-term marriage, the principle is equalization for the most part, and that's 25 years or more. And it's also going to depend on how close you are to retirement, how many working years left, what the situation is. It's very often in a long-term marriage, community property is divided 50-50, and then maybe there's maintenance to equalize the parties. So how long are you married? What's the financial situation of the parties at the time of divorce? And that's going to help determine how your community is divided. So next thing I'm going to talk about briefly before I take more questions is spousal maintenance. So this is really important. Spousal maintenance, it might not be an issue in your case, or it might be. And the question is, first, whether there is spousal maintenance, and the second is like, how much is it, right? And who gets it? So spousal maintenance, what is it? It's post-divorce or temporary support from one party to the other to provide financial resources. Okay. So post-divorce support. if you think about this, not everybody is going to get spousal maintenance based on length of marriage because one party has to actually have the ability to pay, the other party has to have the need, and there are a number of factors to consider. But the basic formula, and I say formula loosely because it's not really a formula, it's a guideline more, I should say, is every 3 to 4 years of marriage is very often 1 year of post-divorce maintenance. So if you're, let's say you're married, let's take 12, because that's a number that's easy to look at. If you were married 12 years, you're going to get probably 3 or 4 years of post-divorce maintenance if you're in a marriage where maintenance is really justified. Where might not it be justified? Where the parties make the same amount of money, or one person makes less or has stable unemployment, but they're unemployed voluntarily, and they're really not trying to get a job. So you might take the position that they should be imputed income to a basic level, and they should at least be able to make that. And then maybe the maintenance is less or it's decreased. And you really have to have an ability to pay. If you have a job, but you really only have enough to take care of yourself and you're not like a high earner, then you really can't afford to pay maintenance and the other person's going to have to deal with it. So maintenance, whether it's an issue, is number one. And then number two is what's the duration and what's necessary to equalize. And that usually requires a much more fact-specific, intensive evaluation to determine what's one party's budget, what's the other party's budget, how much discretionary money is really left, are we looking at equalizing the parties, exiting a marriage in a midterm marriage or in a long-term marriage, or is it a short-term marriage where maybe just a little bit of post-divorce support is necessary to get someone on their feet. So anyway, a lot of factors to consider with maintenance. Any questions, Melissa, that I should take?
Yeah, there's a question here. Okay, wondering if you can amicably decide to leave certain items out of community property. So, and they're specifically asking if they own their own business and their partner didn't have a hand in it, can they agree to leave it out of community property? And
No.
how does a business get evaluated for value?
Yeah, it is community property. So you can't just say, I'm going to leave it out of community property. You can say, I agree that one party gets it. Like, you don't have to agree. You don't have to say, like, we're going to divide it. But it doesn't really matter if the party, if you started it during the marriage, if you used money that's pre-divorce, I'm sorry, pre-marriage. If you use pre-marriage money to start it, or you started it pre-marriage, it's your separate property business. Every piece of property has to be characterized. You can't say, we're just going to pretend this isn't community property. It's going to have to be characterized as separate or community. If it was established during the marriage, it's community. You can decide that you're getting it, and that's okay, but you can't change the character of it. Character of property is established at the time it's acquired. That's a legal principle. So here's the other thing to know, and I should have mentioned this earlier. What is separate property? Separate property are that you could acquire during the marriage would be inheritance that's just to you, would be a gift that's just to you, or it would be income that's derived from a separate property source, a really common one. So let's say you have a rental house before marriage, and then you're getting money from that during the marriage. That's separate property income. Okay. So keep that in mind. But no, you can't change the character of the property or leave it out of community property. You can just decide that you're getting it. The other part of that question was, how does a business get valued? Was that right, Melissa? How it gets valued? Yeah, you need to get a business valuation. Sometimes I'll tell clients it's not worth it. Like, if you have a business and there's no other employees but you, it's not worth it. There is no value of your business for the most part, unless you have some kind of crazy inventory, because the value of the business in like a sole proprietorship or a business that's really only has no employees is just your income. So your income is what you're looking at. If it's a business with employees, it's been operating for a while, you're going to need probably a business valuation. So we will typically hire someone to do a business valuation. If somebody doesn't agree with it, they might hire one on their side as well, but you'll need a professional business valuation. But you'll really want to talk to an attorney first to determine whether that's necessary or, what you're really looking at. So, okay. All
I have
right.
a few more questions.
Yeah,
If
go ahead.
are college funds or custodial accounts and names of children treated as community assets and something to be divided or no?
Yeah. Um, so 529 accounts and any accounts like that are set up for benefit of your children are not to be divided. I mean, they're community because they're from during the community period, so they have to be allocated to someone, but typically they just go with the person whose name that they're in, and that's it. So but they're not divided in a way that they're like being liquidated, and they're not counting as a value on your asset and debt sheet. They're allocated to somebody during the community period, but it's usually just the custodian. And usually what happens is if you have a 529 and it's in one parent's name, then the other parent will probably open up one later. So yeah, good question. Anything else?
Okay, yeah, there's quite a few questions popping up here. If the 90-day clock period passes and the respondent's not responding to the petition, but there was a limited appearance after service.
We're getting
Sorry,
a little fact
a little
specific.
fact specific. Yeah. I'm not even quite grasping what they're asking here. Yeah, I guess what happens if they don't respond?
And then you can seek default if they've never appeared and they've never responded. You could seek default, but you're gonna have to serve them with default. So then they might respond. So it's probably like default is if you really think they're totally off the map. But if they're not, and it sounds like maybe they partially responded or somebody appeared, you're probably not going to get default. But you can serve default.
Okay. Another question here is, what if there's evidence to support that the marriage, like the marriage-like union, like the living together, was established years before the legal marriage actually happened, right? Can the total number of those years be counted in regards to spousal support?
No, you should watch my committed intimate relationship webinar that we've done a few times. You're talking about a committed intimate relationship. I'll touch on that briefly because it's not divorce, but it can be related. So here's a good example. I had a divorce a few years ago. Parties were married for like less than a year, but they were together for 12 before that. So we were really looking at, under Washington's committed intimate relationship doctrine, we were really looking at dividing like 13 years of community property and not one, okay? And however, spousal maintenance is not available in a committed intimate relationship. So you can't tack those years on to get more spousal maintenance. You can tack those years on if you have facts that support a committed intimate relationship and you want to push that narrative, you can do that. But that's only going to increase your interest in the community property to cover those years. Those years don't count towards spousal maintenance. So there's a lot more I could say about committed intimate relationships. It's also known as CIRs. But that answers your question.
Okay. And in the separation of assets and the divorce, if you have to sell your home, at what point do you actually list and sell it?
Depends. If you guys agree to sell it and you want to sell, a lot of the time, like you might agree to sell it earlier in the process because it's the summer, the market's better, you're both in agreement that it's going to need to be sold. You could list it for sale like well before the divorce is over. Or you could have a divorce where you guys agree that you're going to sell it and you negotiate a timeline for selling it and you're agreeing that, well, you guys are going to sell it and you might be divorced, but you still want to sell it as part of the divorce so you get a higher capital gains exemption and you don't want to sell it in winter, so maybe you're going to agree to sell it next spring or whenever you're going to do that. You can agree on anything you want. It's important that it's clear and the terms are clear and who's going to maintain it until then is clear. And if someone's going to get a credit for post-separation contributions or any number of details that need to be worked out, but you can agree on the timeline like really whenever it is. I have a standard kind of a home sale agreement that I'll use for parties depending on when they're selling it, or it might be part of the final settlement agreement too. It depends on what's best for you. Yeah, there's not a hard and fast, you have to do it by now kind of a thing.
Good. I think we're good for the questions as of
All
now.
right. I want to touch on the last two issues as we kind of come in for a landing here. The first one is parenting plan. So if you don't have kids, sorry, you have to listen anyway. Um, anytime that you're getting divorced with kids, you have to have a parenting plan. And so what that's going to do is it's going to give a residential schedule that's going to say where your kids are going to live. Some states, it's called custody. We don't use that. We use parenting plan instead of custody order. We use residential schedule instead of custody time. So what that means is where your kids are going to live and with who. So there's going to be a schedule for that. Can you make other arrangements? Sure. If you guys get along and you want to make your own arrangements, you can. But the parenting plan is kind of the rules of the road to follow if nobody's getting along. Just think of it that way. Or just kind of to dictate what you're going to do. The second thing it's going to do is it's going to dictate holiday time. Where are the kids going to spend the holidays, the breaks, spring break, midwinter break, Christmas, winter break from school, all that kind of good stuff. Other special holidays that might be important. Some people celebrate, Rosh Hashanah. Some people celebrate Diwali. Like there's all kinds of different cultural holidays and religious holidays that also get factored in. Okay. And then another really big thing in a parenting plan is decision making. So while you're married, you're really used to making decisions together. Someone wants to play soccer, one of your kids, you say okay, and it happens. If you're divorced, you guys are going to have to agree on that activity and that expense. So the decision types that are covered generally by a parenting plan: extracurricular activities, non-emergency medical, and educational decisions. Okay, those decisions generally a joint decision unless there's a basis for restrictions against one parent for them not to. If a parent has been neglectful, if a parent has serious substance abuse issues that impede their ability to parent, if a parent has other addiction issues, if a parent has history of domestic violence, those are all reasons to have their decision making and time with the child limited. So that's really important for you to know. That's a basis for restrictions in a plan to restrict decision making potentially and residential time potentially. But for most people, decision making is usually going to be it's usually going to be joint. So your plan will say what kind of decisions are joint. You can have more in there if you want. There's some others that get added if you want to add them, and then what that process is going to be. There's also going to be a dispute resolution provision in there that's required. For some people, that's just going right to court, especially if you have a protection order, then no one's going to make you participate in dispute resolution. That's mediation or arbitration. For most people, I recommend arbitration because that means you'll have a decision maker to make a decision for you very quickly and you won't have to go through a mediation. For some people, they want mediation, and then if there can't be a decision, then arbitration. So, but here's the thing, most common reasons for dispute resolution in a parenting plan are somebody won't agree on a summer camp or an extracurricular activity, or someone won't agree on someone getting braces or any number of things like that. Those are things you usually want a quicker decision on. So arbitration allows you to get that. So you'll have dispute resolution. So you'll have residential time, vacation time, summertime, holiday time, decision making, who's going to pick up the kids when. Those are the main things in a parenting plan. So that's what you've got. The last thing I'm going to touch on before I take questions until the end is child support. Child support is actually the easiest thing to do and the last thing that we decide in a divorce. And the reason why is this. We have a statutory formula that really tells us how much do you make, right? What are the allowable deductions and what is the what's the net result, right? And then once we know that, we know what the income is, and you know how many kids you have, then you can see what the child support number is supposed to be. So once you know what the child support number is supposed to be, then you look at which parent has what percentage of that number. Let's say one parent makes less, maybe they only make 30% compared to the other parent. Parent makes 70%. The parent that has the kid more nights receives the child support transfer payment from the other. That's intended to cover food, shelter, clothing, basic life necessities. The things that are not covered are out-of-pocket medical, extracurriculars, and work-related childcare. Those are really the big ones. And those are usually covered along proportional share. So if one parent made 30% on the child support worksheets, one parent made 70, that's how much they will each pay towards those expenses. So that is the nuts and bolts. And the really important thing to know, and the reason it's often not decided until later, is that, if you're paying spousal maintenance, that's a deduction to you on the child support worksheet. That's reducing your net income. If you're receiving it, that shows as income and household money to you on the child support worksheet. So if we don't know what the maintenance is going to be, we don't know what the post-divorce child support is going to be. So that's part of it too. So anyway, I hope that's helpful. I will take some questions.
Yes. How long does it typically take to receive the final divorce decree from the court after a default order has been issued?
I mean, if a default order is issued, that's the final order. Like they'll issue final orders.
Okay.
Yeah.
Another question, can you describe the difference between a divorce and a legal separation?
Yeah, I was going to talk about that. I'm glad you asked. Yeah, difference between divorce and legal separation, hardly anything. So, except for that you're still married. You'll still do all the four things I talked about. Divide debts and assets, determine spousal support, enter a parenting plan, and a child support order. All those things will happen. Legal separation, though, you're still legally married. Either party at the end of a legal separation can wait 6 months from the finalization of a legal separation and convert to a divorce. Anybody can do that, and you can't stop them from doing it. You just have to serve notice to the other party and you can convert. So the main reason people would do legal separation is number one, sometimes it's easier for the other party to kind of wrap their mind around that, and that might feel less adversarial at the time. But more commonly is if one person is trying to leave the other person on their benefits. But I caution you on this because many employers will not allow someone to stay on benefits once you're legally separated because you're financially separated. Others, though, will. So you really will need to check on that, but that can be a reason why. And the third reason why is religious reasons. Some people just they don't believe in divorce, and so they'll legally separate instead of divorcing. So the differences, though, are very few, except for that you're still married legally, but you even file taxes separately. Like you'll file as single post-legal separation. So you do all the same things, you're just technically still married. And either a divorce or a legal separation can be dismissed. So some people will just be like, well, I just filed legal separation because I want to be able to dismiss it if we got back together or whatever. You can dismiss a divorce too. It doesn't really matter if you both agree. So
All right. And then another question here, texts. Is there an app or a method that you can recommend that we share text communication on besides 1,000 screenshots? Like how to share text communication.
with who?
I'm assuming with the legal people rather than
Oh.
sending.
I mean, you can download them I mean, it depends on what you have. Like if you have iMessage or if you're talking about, okay, let me clarify this. If you're talking about like if you're co-parenting with somebody or you have an ex, and you're co-parenting with them and you have a high conflict situation, it can be really helpful for you to utilize our Family Wizard or a co-parenting application that stores all your messages. It also has a joint calendar and it tells you when people read messages. I highly recommend our Family Wizard. If you are just talking about like trying to download all your screenshots and text for your legal team, one thing you can do is if you have iMessage, you can always go on to your desktop iMessage and you can export your entire conversation history that way, and give it to them. I don't actually, there's a couple other applications that you can use too to export from your phone. So there's a variety of those. I mean, I'm not going to really endorse any specific one because I don't actually think any of them are that great. But you can find one. I think there's 4 or 5 that are at least 4 stars or above that you could find on any app store. So that's like to export text messages. Otherwise, like screenshots are fine. It can be kind of cumbersome, but just like I talked to you about earlier, just with organizing anything, be like text messages from here to here and give a date range and put them all in a folder. I mean, that's a really easy way to do it too. But I highly recommend exporting your entire iMessage conversation if that's easier. And then you can go through and highlight what's important. So.
Okay. Okay. Do legal fees incurred during the divorce process count in the division of community property?
Do they count?
Do they, I guess, how do they get factored in? Why don't we just talk about how legal fees
Okay.
might get factored in?
Well, I mean,
Probably the last question because we are wrapping up here.
yeah, and here's the thing to think about. So if you if you've incurred a bunch of legal fees and the other parties have incurred a bunch of legal fees, you might have a situation where you agree that the community is you're gonna both pay your fees out of the community off the top before settlement. Or you might have a situation where you end up getting a order for the other party to pay your fees. Like if the other party has resources and you don't, fees can be awarded in Washington based on need and ability to pay under Title 26, which is the chapter that governs domestic relations. So you might be able to get fees from the other party out of post-separation money, or you might agree to have those paid by the community, or sometimes you might agree that each party keeps their own fees. It really depends on the specifics of your situations. There's not like a hard and fast rule, but the law in Washington is that fees can be awarded based on need and ability to pay. And if you're getting a protection order against someone, fees can be awarded by statute. We didn't really have a lot of time to talk about protection orders because that's not really Divorce 101, but it is a very important thing and it is something that often happens at the beginning of a case. And I think we have other resources. I know we have other resources online on the YouTube channel if you want to hear all about protection orders.
Yeah.
So I
I do
think
want to say
that's,
I
yeah,
do want to say one thing. Dellino Family Law Group is doing a Mariners ticket giveaway, and just, as
we
a thank
are.
you for joining us today, everybody here on this webinar is eligible to enter the Mariners ticket giveaway for the game that's going to be on Friday, August 22nd at 7:10 p.m. So anyone who's been on this webinar is going to get an email to fill out a quick form and to enter you into the giveaway. And then winners will be notified on August 15th, about a week before the game. So just wanted to let you know about that fun opportunity. And as a thank you for attending the webinar, you're eligible to attend or to be entered into the contest to win the tickets. So that's kind of a fun thing.
You should totally do it. We had another game earlier this summer, a bunch of people got to go to, so you should totally do it if you're here, definitely. Hopefully you can go to the game.
Yeah. And we do these webinars every month. This Divorce Foundation series is a monthly series at this point. And we also have topic specific webinars once a month as well. So keep an eye out for those. I'm putting a contact slide here in case you'd like to reach out and schedule a consultation. We'd love to hear from you and be able to deliver more information as well. So thanks for participating today. Lots of great questions today.
Yeah, I did want to follow up and just say that July 24th is our Committed Intimate Relationship webinar. We've done that a few times. We're doing another one on July 24th. So if you want to know, and that relates to unmarried couples and it relates to if you're married but you lived together before you were married and you want to know about whether that period of time might count as a committed intimate relationship, that'd be a really good opportunity for you to check out. We also have a meetup group that's pretty great. We meet every month. Usually it's the last Wednesday of the month. I'm gonna see, sometimes it changes just given like let's see. given schedules, but we do, yeah, July 30th, we're doing the last week this month. July 30th from 5 to 7 p.m. we're meeting on Zoom. I think our next in-person is going to be in September. We do meet in Bellevue, usually once a quarter, at least a couple times a year in person. But every month we do a divorce and separation meetup at the end of the month. So you're welcome to come to that, ask more questions as well. So that's a little bit slightly different format, a little less lecture and a little more questions. So hopefully that's good for you. But feel free to go to our YouTube channel. There's a ton of stuff there. Feel free to look for me on TikTok. I'll answer your questions there as well. Yeah, and wish you well. Thanks for coming and thanks for the great questions. Have a nice day. Bye-bye.
Thanks, everyone. Appreciate you being here. Appreciate your questions, and we hope to see you again next time. Thanks so much. I'll leave this slide up for just another minute or so.